Hello dear students, welcome to IAS Viewpoint, the point of success. Today's topic is judicial review. The roots of the doctrine of judicial review can be traced to Dr. Bonham's case in the year 1610 when Lord Chief Justice Coke of England declared an Act of Parliament which had put its seal on the Charter of Royal College of Physics as void. After the English Revolution of 1688, the supremacy of the Parliament assumed the significance along with the unwritten constitution of the United Kingdom. This may be one of the reasons why the doctrine of judicial review of parliamentary legislation did not evolve well in the United Kingdom, although this principle was applied to a certain extent in some of the colonies that were ruled by the British. The principle of judicial review was first established in the US in the famous case of Marbury versus James Madison by the then Chief Justice of the United States of America, John Marshall. Later on, the principle of judicial review became an essential feature of written constitutions of many countries. Canada, Australia, and India are some of the examples. In Australia, there is Australian Administrative Procedures Judicial Review Act 1977 to regulate judicial review. In India, Emperor versus Bura was the first case which gave birth to the concept of judicial review in 1877. In this case, the court held that the aggrieved party had right to challenge the constitutionality of a legislative act enacted by the Governor General Council in excess of the power given to him by the Imperial Parliament. In the same case, the High Court and Privy Council adopted the view that Indian courts had power of judicial review with some limitations. The idea of judicial review is implicit in the establishment of Federal Court of India, which was established under the provisions of the Government of India Act 1935. What is judicial review? Smith and Jurcher defined the judicial review as the examination or review by the courts in cases actually before them of legislative statutes and executive or administrative acts to determine whether or not they are prohibited by a written constitution or are in excess of powers granted by it, and if so, to declare them void and of no effect. And Edward S. Corwin, he says, judicial review is a power and duty of the courts to disallow all legislative or executive acts of either the central or the state governments which, in the court's opinion, transgresses the Constitution. And Justice P.N. Bhagwati in Minerva Mills case, he says, it is for the judiciary to uphold the constitutional values and to enforce the constitutional limitations. That is the essence of the rule of law, which inter alia requires that the exercise of powers by the government, whether it be the legislative or the executive or any other authority, be conditioned by the Constitution and the law. In simple words, judicial review is the power of judiciary to examine if a law or an action by the organs of the government is violative of the Constitution or not. If the spirit of the Constitution is not followed, the said law or an action shall be declared as unconstitutional and unenforceable. Legislature, executive and judiciary are the three organs of the government. The government includes the central and the state governments. The doctrine of judicial review is based on principles of rule of law and separation of powers. Caroline Kennedy says, the bedrock of our democracy is the rule of law, and that means we have to have an independent judiciary, judges who can make decisions independent of the political winds that are blowing. Judicial review is an essential component of the rule of law. Judicial review applies only to the questions of law and generally not to be exercised in respect of political issues. Judicial review in India is governed by the principle procedure established by law. The court tests if the law is made in accordance with the powers granted by the Constitution or not. If yes, whether the prescribed procedure is followed or not. If the law fails this test, then it is declared as unconstitutional and hence non-enforceable. The courts can invalidate either the entire law or a part of it. Even if a part of the law is invalidated, the remaining part of the law is operable. However, please note, if the invalidated part is so significant to the law such that the other parts cannot operate without it, then the whole of the law gets rejected. And when we come to the scope of the law, the scope of judicial review in India is narrower than the United States of America. The US follows the principle of due process of law. The due process of law gives wider scope to the Supreme Court. Procedure established by law is the constitutional doctrine which is followed in India. It is apt to recollect that our Parliament works well within the Constitution. Our Parliament is not supreme as the British Parliament. The judicial assessment is technologically advanced as an indispensable feature in the countries wherever written constitution is adopted. Judicial review is concerned not with decision but with decision making process. What is the importance of judicial review? Judicial review is very important to uphold the supremacy of the Constitution. It is also important to maintain federal equilibrium, that is, to maintain the balance between the center and the states. Judicial review is also very important to protect the enforcement of fundamental rights. It protects the fundamental rights of the citizens. Justice Bhagwati in Rajasthan versus Union of India case in 1977 observes, the Constitution is supreme lex, the permanent law of the land, and there is no branch of government above it. Every organ of government, be it the executive or the legislature or the judiciary, derives its authority from the Constitution, and it has to act within the limits of its authority. No one, however highly placed, and no authority, however lofty, can claim that it shall be the sole judge of the extent of its power under the Constitution, or whether its action is within the confines of such power laid by the Constitution. This court is the ultimate interpreter of the Constitution, and to this court is assigned the delicate task of determining what is the power conferred on each branch of government, whether it is limited, and if so, what are the limits, and whether any action of that branch transgresses such limits. We can also observe a quote from Justice Ramaswamy in S.S. Bola versus B.D. Sharma case in 1997. It is said, the founding fathers very wisely therefore incorporated in the Constitution itself the provisions of judicial review so as to maintain the balance of federalism, to protect the fundamental rights and fundamental freedoms guaranteed to the citizens, and to afford a useful weapon for availability, availment, and enjoyment of equality, liberty, and fundamental freedoms, and to help to create a healthy nationalism. The function of judicial review is a part of the constitutional interpretation itself. I repeat, the function of judicial review is a part of the constitutional interpretation itself, as said by Justice Ramaswamy. He also continued to say, it adjusts the Constitution to meet new conditions and needs of the time. Very wonderfully said by Justice Ramaswamy in S.S. Bola versus B.D. Sharma case. Next, judicial review may be broadly categorized under three heads: judicial review of legislative actions, judicial review of administrative actions, and third one, judicial review of judicial actions. What is legislative action? Legislation is the process of lawmaking by the competent authority. The term state includes the government and Parliament of India, and the governments and the legislatures of each state, and all local and other authorities within the territory of India are under the control of the Government of India. The word law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. Articles 245, 246 and 7th schedule of the Indian Constitution very clearly provide for the distribution of legislative powers. Chief Justice Kanya stated in A.K. Gopalan versus State of Madras case in 1950 that in India it is the Constitution that is supreme, and that a constitute law to be valid must be in conformity with the constitutional requirements, and it is for the judiciary to decide whether any enactment is constitutional or not. The judicial review of administrative actions is very important. By the very nature, modern society is fast changing. With its welfare dynamics, the state creeps into the lives of its citizens to a considerable degree. Under these circumstances, the administrative action may affect the rights of citizens. Administrative action is residuary action which is neither legislative nor judiciary. Administrative actions can be quasi-legislative, quasi-judicial, or purely administrative. Quasi-legislative actions include, among others, making rules, regulations, and other statutory instruments for the smooth execution of laws enacted. Quasi-legislative actions are the functions of subordinate legislation. The power to supplement legislation is known as delegated legislation or subordinate legislation. This delegated legislation becomes inevitable, a must, due to many reasons such as emerging circumstances of the society, increase in burden of parliament, the technical nature of law to be legislated, which can best be handled by the subject experts, and unforeseen difficulties which arise while implementing laws. These aspects make delegated legislation very important. Guided delegated legislation is considered effective and efficient for the administration. However, these should not go against the essence or the spirit of the main act. When the decisions or actions taken by the executive are judicial in nature, they are considered quasi-judicial. When the executive simply implements the laws passed by the competent authority, they are treated as purely administrative actions. Although the administrative action is mostly discretionary and subjective in nature, the executive authority must act fairly and reasonably. Administrative actions are open to judicial review. They are bound by principles of natural justice. Remember, all the administrative actions are open to judicial review and bound by principles of natural justice. Judicial review of judicial actions imply reviewing of its own decisions taken previously. Judicial review is different from the appeal. Remember, judicial review is different from appeal. The right of appeal is a statutory right. It can be invoked as per the relevant act. The right to seek judicial review is available even when there is a finality clause or ouster clause. The finality clause implies that the order passed by authority is final. Ouster clause implies that it shall not be questioned in the court of law. The matter concerned shall not be questioned in the court of law. That is the meaning of ouster clause. The grounds for judicial review. The grounds for judicial review were summarized by Lord Diplock of England in the case of Council of Civil Services Union versus Minister of Civil Services in 1985. See, if we go by this list given by Lord Diplock, we find the elements illegality, irrationality, procedural impropriety, proportionality, and legitimate expectations. Remember, the list of these grounds is not exhaustive, not complete. We may add, it is just a list given by Lord Diplock. What exactly do we mean by illegality? Just understand the term jurisdiction. Jurisdiction means the official power to make legal decisions and judgments. And illegality includes lack of jurisdiction, excess of jurisdiction, abuse of jurisdiction, or any sort of jurisdictional error. On this ground, judicial review can be called for. Another ground is irrationality. A decision is irrational if it is so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question could have arrived at it. That means it is not reasonable. This standard is also known as Wensbury unreasonableness. This standard is also known as Wensbury unreasonableness. And another ground is procedural impropriety. It implies a failure to comply with the laid down procedures. There are a number of established procedures. If they fail to follow those established procedures, it shall be a ground for judicial review. And another ground is proportionality. Proportionality is a requirement that a decision is proportionate to the aim that it seeks to achieve. For example, let's say in order to forbid a protest march on the grounds of public safety should not be made if there is an alternative way of protecting public safety, such as by assigning an alternative route for the march. A legitimate expectation is another ground. A legitimate expectation will arise when a person has been led by a policy, promise, or representation of a public body to understand that, for example, certain steps will be followed in reaching a decision. If they do not follow those steps, then a legitimate expectation is broken. It is not just for a person. The legitimate expectation can be a group or for a class of persons. Then, what are the constitutional provisions which are there for judicial review in the Indian Constitution? Although the phrase judicial review is not used in the Constitution, the idea or the spirit of judicial review can be reflected in many articles of the Constitution. See, Article 13 declares that all laws that are inconsistent with fundamental rights shall be null and void. Article 32 guarantees the right to move the Supreme Court for the enforcement of fundamental rights and empowers the Supreme Court to issue directions and orders or writs for that purpose. Article 131 grants the Supreme Court the original jurisdiction in matters of center state and interstate disputes. Articles 132, 133, 134 provide for the appellate jurisdiction of the Supreme Court in constitutional, civil and criminal cases respectively. Article 134A talks of the certificate for appeal to the Supreme Court from the High Courts. And Article 35 empowers the Supreme Court to exercise the jurisdiction and powers of the federal court under any pre-constitutional law. And Article 33, according to that article, the Supreme Court can grant special leave to appeal from any court or tribunal except military tribunal or court-martial. Under Article 143, the President is authorized to seek the opinion of the Supreme Court on any question of law or fact and on any pre-constitutional legal matters. Article 226 empowers the High Courts to issue directions, orders or writs for enforcement of fundamental rights and for any other purpose. Remember, 226, it empowers the High Courts to issue writs, directions, orders, not just in the matters of fundamental rights or for any other matters or any other purpose as well. Article 227 grants the High Courts the power of superintendence over all courts and tribunals within their respective territorial jurisdictions except military courts or tribunals. Article 245 deals with the territorial extent of laws made by Parliament and by the legislatures of states. Article 246 deals with the subject matter of laws made by the Parliament and the legislatures of the states, that is the Union list, State list and Concurrent list. Articles 251, 254, they state that in case of the conflict between the central law and state law, the central law prevails over the state law and the state law shall be void. And even Article 372 deals with the continuance in force of the pre-constitutional laws. Right. And with regard to basic structure and 9th schedule, we need to discuss one or two points here. Is judicial review part of basic structure of the Constitution? Yes. Judicial review is part of the basic structure of the Constitution. The basic structure doctrine is a common law legal doctrine. As for the basic structure doctrine, the Constitution of a sovereign state has certain characteristics that cannot be erased by its legislature. Parliament by law cannot erase certain features, certain characteristics which a sovereign state has got. And judicial review is one such character or feature. Through various judgments, the judiciary reaffirmed judicial review as part of the basic structure. Justice Khanna in Kesavananda Bharati versus State of Kerala 1973 asserted that as long as some fundamental rights exist and are a part of the Constitution, the power of judicial review has also to be exercised with a view to see that the guarantees afforded by these rights are not contravened. And what is to do with this 9th schedule? Judicial review cannot be conducted in respect of the laws incorporated in the 9th schedule of the Constitution. But remember that the Supreme Court judgment laid that the laws placed under 9th schedule after 24th of April 1973, that is the Kesavananda Bharati case judgment day. This 9th schedule shall be open to challenge in court if they violate fundamental rights guaranteed under Article 14, 19, 20 and 21 of the Constitution. So, whatever were placed before 24th of April 1973, they shall not attract judicial review. But the laws placed in 9th schedule after that date are open to judicial review if they violate fundamental rights under Article 14, 19, 20 and 21. What is the criticism of judicial review? Judicial review is criticized on the ground that it is undemocratic. It is said that it undermines the powers vested in the representatives of the democracy. It also tends to make the parliament less responsible. The concept of judicial review is not clearly specified in the Constitution. When the courts declare a law or an executive action as unconstitutional, it may create some kind of administrative problems as well. There is a possibility for judicial tyranny. Remember, at times the fate of a law is determined by a majority of a single judge when a bench of the Supreme Court hears the constitutional matters. We have the history of that sort. Sometimes there are a reversal of its own decisions by the Supreme Court. These are some of the criticisms on the notion of judicial review. See, as the saying goes, all power is of an encroaching nature. All power is of an encroaching nature. Judicial power is no exception to that. It is the delicate task of balancing exercise of power and not crossing the boundary limits which is vested in the judiciary. Self-restraint is one of the best guards of all against the judiciary boundaries. So, in order to not to cross the boundaries, the judiciary has to maintain self-restraint. It is also to be understood that judicial review is not unqualified and unlimited. It does have some sort of restrictions. Let me conclude this session with Granville Austin's saying. Granville Austin, in his book The Indian Constitution, Cornerstone of a Nation, he says, the judiciary was to be an arm of the social revolution, upholding the equality that Indians have longed for during colonial days, but had not gained, not simply because the regime was colonial and perforce repressive, but largely because the British had feared that social change would endanger their rule. The courts were also idealized because, as guardians of the Constitution, there would be expression of the new law created by Indians for Indians. Judicial review, assembly members in fact believed, was an essential power for the courts of a free India with a federal constitution. Dear students, I think we have covered almost all the dimensions of the concept judicial review, and this would be really helpful for your prelims as well as for your mains. I request you guys, if you have really liked this session, please do subscribe to our YouTube channel and join our Telegram channel. We plan to come up with number of sessions of this sort, and we will also come out with different programs which will enrich you and help you in your success. Thank you.